Good evening, friends. I extend a very warm welcome to all for this 47th webinar of Corporate Professional. Friends, today we have taken up the topic practical aspects and nuances of prosecution under new Benami law. This topic is bothering like a sword of Damocles on business persons, promoter, and common citizen ever since it was amended in 2016. Today, we have invited galaxy of speakers for this program. Those who are acted as those who have decided the matters, those who are practicing, and those who are advising in the court. So today, we have invited none other than Dr. R.N. Das. Dr. R.N. Das belongs to 1976 batch of Indian Revenue Services, retired in 2012 as Director General of International Taxation. And after that, he became member judge in the Appellate Tribunal under the Prevention of Money Laundering for 4 years, and also acting chairman of the tribunal when he quits the job. Dr. Das also worked for UNO and African Development Bank as consultant. He has the doctorate degree in business administration, degree in law, and double master's degree, and he's currently practicing as advocate. We welcome you, Dr. R.N. Das, for this program. Then we have another brilliant professional, Dr. Rakesh Gupta, who has a brilliant academic records, always being a merit holder and university topper. He is perhaps one of the most qualified professional among FCA, FCS, ICWA, MBA, LLB, LLM, and PhD. So Dr. Gupta, he has been member of Income Tax Appellate Tribunal and is currently practicing as an advocate, regularly appearing in Income Tax Tribunal, High Court, Supreme Court, and he has argued several high-profile cases during his wide range of career. He is sought after speaker on professional forum and also co-authored various books on income tax. I welcome Dr. Gupta for this program. Then we have another speaker and another stalwart, C.A. Ashwini Taneja. Ashwini Taneja is a conquered career, having practiced as chartered accountant, having been member of Income Tax Appellate Tribunal, and currently practicing as advocate. Besides CA, CS, and CWA, he is a fellow member of Indian Council of Arbitration and also done his LLM. As a member of ITAT, he created a sort of record by delivering more than 2,000 judgments in a short span of time. Number of orders authored by him and cases argued by him have been published in leading law journal. We welcome Ashwini Taneja ji for this program. Then we have Amit Khemka ji. Amit Khemka ji is practicing as a litigation lawyer in Supreme Court, High Court, and other courts of the country and tribunal, and has handled large number of cases involving complex issues, some of which have been headlines. He also regularly participating in debate on All India Radio, various VC channels, TV channel, and deliver lectures at different forums. I welcome Amit Khemka ji for this program. So friends, now you can see that we have multiple and the distinguished speaker today to discuss this very complex issue. Friends, as you all are aware, the Benami Transaction Prohibition Act 1988 was enacted to prohibit Benami transaction and the right to recover property held Benami. However, during the administration of this act, it was found that its provisions were inadequate to deal with Benami transaction, as the original act did not contain any specific provision for vesting of confiscated property with central government, did not have any provision for the appellate mechanism against an action taken by the authorities under the act while barring the jurisdiction of a civil court, then did not confer the power of the civil court upon the authorities for its implementation, and did not provide for adequate enabling rule-making powers. These were the lacuna of 1988 Act. In view of this comprehensive amendment to Benami Transaction, Prohibition Act 1988 was made by the Amendment Act of 2016. The amendment provides definition of Benami transaction, Benami property, and also provides for exclusion and transaction which shall not be construed Benami. Exemption was also there. Then power to acquire Benami property and person liable to be prosecuted who is guilty under the Benami property. So this was the feature of 2016 amendment. It also provides the consequence of entering into prohibited Benami transaction and lays down the procedure for determination and related penal consequences in the case of prohibited Benami transaction. It also provides that the power of civil court shall be available to authorities under the said act. The simple word of Benami is holding the property in the name of another. That is a Benami. Normally seen an easy concept that somebody is holding property in another name, that is a Benami. But the legal position is quite complex and complicated, and several fundamental and integrity issues being faced. In fact, the amended law is left with several loopholes that seem quite harsh. Certain areas, particularly with respect to ignoring the element of mens rea, giving retrospective effect to several amendments, and ignoring our social setup of joint Hindu family, have been creating unwanted and complicated situation. If the transaction done on property held in Benami, whether knowingly or unknowingly, with mala fide or bona fide intention, it would be treated as Benami and prohibited under the law along with civil and criminal consequences. The amended law has thus affected particularly every citizen in every walk of life. With view to understand its implication, practical aspects and nuances of the new law and how to face prosecution initiated under it, we have invited battery of top experts in the area who will demystify and unfold the complexity. Without going into further detail, I will now invite our distinguished speaker, first C. Ashwini Taneja ji, to discuss about this concept of the new Benami law. Over to Ashwini Taneja.
Respected Dash sir, respected Dr. Gupta, my guru and my partner, respected Amit Bhai, and our lovely, handsome, dynamic Pawan Vijay ji. It is really a pleasure to be in the enriching company of all of you. That itself is giving me a lot of good vibration, good energy. Pawan ji was sharing a few minutes back that I am today making these deliberations from Chandigarh, which was otherwise not possible when this technology was not evolved, because I had to make a choice whether to give deliberations on this webinar or to appear before the Honorable High Court of Chandigarh. But because of this technology, it could be possible, and energy of all of you really pulled me that I should not miss it. And particularly, Pawanji has always been admiring the kind of audience magnetically which Pawanji is able to pull. That is very highly intellectual audience, very motivated, and very encouraging questions, queries, suggestions would come from this audience. So with that enthusiasm, really, I am really thankful to all of you for joining. And I will, because time is really limited, the topic is so vast that any length of time will be short, but I will try to justify in crisp manner to convey my thoughts on the basic understanding of this word Benami and the law which has been brought. Pawanji spoke many things, and most of them were quite scary. So whatever Pawanji said, is it truth? And if it is truth, whether it is rational, it is fair, it is believable. Friends, believe me or not, whatever Pawanji spoke, each word of that was truth as far as the correct legal position is concerned today. However, it may be rational, it may not be rational. Ultimately, it will help the economy or it will dent more than help the economy. I do not know. But one thing you would have noticed, my dear friends, that during last couple of years, the emphasis of our government has been to lay emphasis more than the emphasis which are put on the collection of taxes by way of income tax or GST or any taxes. So enforcement of laws dealing with economic offenses has been receiving special emphasis in last couple of years, which include amongst others. The top one is Benami law, then Prevention of Money Laundering Act, recently introduced Black Money Act, FEMA, and few other things in the pipeline, still more to come. So one thing is clear, that our economy needed it, these kind of enforcement of these laws, and therefore government is putting a lot of emphasis upon it. Therefore, it becomes our bounden duty to understand it as a professional or as an executive in a corporate or as an SSE or as a citizen of this country, to understand the laws and to also ensure that intended or unintended non-compliance of any of these laws does not take place. Because friends, I have realized one thing, that the cost of non-compliance has become too high today. Maybe a few years back, the cost of compliance was higher and the cost of non-compliance was lower. But now it is reverse. Cost of non-compliance is too high and cost of compliance is here. So non-compliance is going to cost a lot. There are lot many consequences, maybe financial, maybe others like prosecution, etc., which Khemka ji will be taking up today. But consequences are really severe. So we must analyze each of these laws, understand how and in what manner we have to make compliance of that. So there is a lot to be discussed about Benami. I will be giving some bird's eye view today, and from there other learned speakers can take it forward. Dr. Gupta is going to speak wonderfully on one of the crucial issues, that how misuse of this law is taking place or improper implementation is happening, that vis-a-vis section interplay between section 68 and section 290, etc. So I hope I am allowed share screen.
Yeah.
All right.
You will
So
just Ashwini sir.
Yes, it is allowed. Yes.
It is visible now.
Yes, right, sir. Thank you, sir. So you must have seen this picture in newspaper. These two chimpanzees were attached by the enforcement directorate. So somebody would say, I mean, how chimpanzees attachment by enforcement directorate, how is that possible? I mean, the spectrum of these laws is so wide, connect is so wide, that we cannot even imagine that what kind of situations will be covered. Now, with respect to these chimpanzees, the answer was that scheduled offense was committed of Wildlife Protection Act, and some forgery was committed with regard to the certificate for obtaining these chimpanzees. And that is how when the scheduled offense is committed and anything derived therefrom is treated as pursuits of crime, and pursuits of crime can be attached by the AD under section 5 of PMLA. That is how it came. Then you must have read this news in the newspaper. Then Modi's new law has companies running for cover, and so many properties have been attached all over the country, and still more to come. I mean, this is old news. Now probably multi times of this property, whatever figure has been given here, has been attached, and cases are going on from all over the country, and covering wide variety of cases, wide variety of people, wide variety of properties, wide variety of cases, covering wide profile, which I will share with you. Then this news is very, very important for us to know and understand. Multi-agency scrutiny. The way things are moving, practically the laws have been created in this manner, and the coordination amongst the agencies is being created in this manner, that there will be simultaneous application of more than one law. Many laws on a particular given transaction can be parallelly made applicable and enforced, be it Companies Act, Income Tax Act, Benami, PMLA, and the provisions have been drafted in such a manner that every law has got its independent application, even if the already action has been taken under the other law. So all the laws are in addition to the other laws. So there could be a situation where there would be cumulative application of laws. So therefore I say there is going to be strong interplay. So before analyzing a transaction, legality of a transaction, we need to analyze whether a particular transaction is having its impact in one area or more than that area. So, I mean, in times to come, we will deliberate in detail how this particular Benami law or how one transaction will have interconnected application or bearing in many laws simultaneously. Now, the finding of the agencies of late has been that the most common ingredient found in violation of laws related to economic offenses would be transactions done are benami in nature. Why it is so? It is because whenever some violation will be done, the chances are the offender or the violator will most probably do the transaction in some other name, pseudo name, some other name, etc., to conceal the identity, to hide the transaction, to do it in a non-transparent manner. So benami angle will be involved in domestic transactions, in international transactions, many type of transactions. So therefore, it is essential to understand the concept of benami firstly. Now, if you ask me that, Mr. Taneja, how would you explain the concept of benami in nutshell? So in nutshell, I would say it is something like that. Wherever the concept of duality comes into picture, benami checks in. How? Now, I correlate it with the Srimad Bhagavad Gita sometimes, that Shri Krishna said, the problem with the human being arises when he creates duality. Meaning thereby, when he feels that he is different from that supreme energy, that supreme energy is different, he is different, and there is a duality between the two. When the duality comes, problem comes. So probably taking this same concept further, here also when the duality in the ownership comes, benami comes. So for a particular asset or a property, there has to be an absolute owner who can be said to be a legal owner, the real owner, the beneficial owner, or whatever terms you may ascribe to. Problem comes when there is a divide between the ownerships, types of ownerships. So ownership is divided at least into two parts. That a particular person, say Mr. X is the legal owner of a particular property, and Mr. Y is the real owner or the beneficial owner of the property. So duality comes. So ownership is divided into two parts. Then checks in benami, concept of benami. So this is on a broad spectrum. Certain other things have also been infused, but the basic underlying concept remains the same. Now, for example, in the slide which is there before you, so there is one gentleman, he is seller, namely B. Another gentleman is the beneficial owner, who is A. So A is making payment to Mr. B for a particular property, but seller is transferring the property, title of the property in the name of Mr. C. So C owns the property legally. He is the ostensible owner, whereas A exercises the control on the real ownership of the property, the fruits of the property, the usage of the property, dominion and control over the property. So in this example which I have quoted, A can be said to be beneficial owner, C can be said to be benamidar, and B is of course the seller. So instead of one party remaining at a time, there would be two parties. After B goes out of the picture, so two parties remain, A and C. Otherwise, in normally what should have happened? The seller should have sold the property to Mr. A. So after B, A should have been the sole party, but two parties come into existence. So wherever the situation is like that, fundamentally speaking, there would be situation of benami, something benami. Now, benami word is from Persian origin. So that means benami transactions have been happening since when the Persian language was in vogue in our country. So since ancient time, benami transactions are happening. So much so, even the legislation which was drafted at that time, that is namely Indian Trust Act 1882, it expressly allowed benami transactions to happen. Not only that, our own Income Tax Act, that is 1961 Income Tax Act, Section 281A of Income Tax Act, allowed benami transaction. It endorsed benami transaction with only one rider, that is information should be given to Commissioner or Chief Commissioner. But somehow suddenly in 1988, one law was introduced to curb these transactions, but that remained in inactive mode because of non-implementation, because of non-creation of the enforcement agencies. So that is it. That is why it remained in inactive mode. It remained a lifeless tiger, and life was infused in that tiger in 2016, 1/11/2016, when it was substantially amended, and the enforcement agency was created in the name of Benami Prohibition Unit, and the enforcement officer is called as initiating officer. Now you may be wondering, what are the reasons why benami transactions are done by people? There are many reasons, and Law Commission time to time has deliberated a lot upon it. Even prior to introduction of the present law, Standing Committee on Finance under the chairmanship of Mr. Virappa Moily, the former law minister, also gave its report, more than 200 pages report, wherein the present bill, which converted into act later on, was deliberated upon. And it was opined that if this law is introduced in the present form, then there will be chaos in the country, because more than 50% of India, whether rural or urban, may be treated as benami, and the consequences are going to be disastrous. That is what they opined. So therefore, in a way, they were saying that it should be substantially amended. But in its wisdom, honorable government thought it fit to introduce in the same form, and that is how we are facing with this law, Benami law. And whatever was opined by Shri Virappa Moily is, coming true. That is what I also opined in 2017 when my interview with regard to the property attached of Shah Rukh Khan was published, wherein I had said this is an, unguided missile, unwittingly created, loaded with nuclear arsenal. So that is what is happening today. So the reason could be violation of certain land reform laws, tax evasion, some black money introduced in some other manner, fraud on creditors, other some corrupt practice. There are numerous reasons. But normally we have noticed that whenever there is a Benami transaction, either some law is being violated or there is some tax evasion. But tax evasion, I have seen it is the lesser cause. The larger cause is violation of certain laws, which could be numerous, which we will discuss in detail when we touch upon the practical examples. So the way present Benami law has been drafted, I would salute the person, the gentleman or the team, whosoever has drafted this law, because it is a fantastic piece of legislation, friends. Without saying much, they have said everything. Without covering much expressly, they have indirectly covered all possible life situations to cover any Benami situation. The definition itself is exhaustively drafted. It has 4 parts: Part A, Part B, Part C, and Part D. Part A is the classic section of Benami. It says where a property is transferred to or held by benamidar and consideration is paid by the beneficial owner and the property is held for the benefit of the beneficial owner. So two conditions have to be simultaneously fulfilled. Consideration should be paid by beneficial owner and property should be held for the benefit of the beneficial owner. So both the conditions should be simultaneously fulfilled. If only one condition is fulfilled, then I think it will not be treated as Benami. Because in that case, there could be other reasons. There could be a transaction of loan, etc. There could be other parameters. But to put into the category of Benami, there has to be simultaneous application of law. Simultaneously application of fulfillment of both the conditions. Now, this is the most prevalent class of Benami transactions, which is defined and covered by Part A of the definition. Part A means 2, subsection 2, subsection 9, subsection A, capital A. And the other part is defined by 29B, which straight away says property held in fictitious name is Benami. Now, fictitious word has been used for the first time in any legislation I have seen. Now, here fictitious would probably denote, and the underlying intention was to cover those situations where the property is held in the name of non-existent persons. For example, in the name of any goddess, any pet, etc., etc. So any such property held in any name is straight away Benami. No need to prove anything more. The moment it is proved that this person is non-existent, property held is Benami. And when the property held is Benami, consequences are very severe. Consequences are so severe that straight away property becomes the property of the government. And various other consequences with other learned speakers, Amit Khemka would cover under that. And further guidance would be given by Honorable Shri Dash. Then Part C, where the owner of the property is not aware of the ownership or denies the benefit or denies the factum of the ownership. So owner means here what they are talking about is the legal ownership, ostensible ownership. So property is registered in the name of Mr. C. And if asked, Mr. C says, oh, is this property? Okay, my property. Sorry, I don't know about it. Or he says, no, I am not the owner of the property. So all such cases where casual statements are given at the time of search are going to cost a lot. For example, when questions are asked from the ladies and ladies would deny, oh, am I the shareholder? Sorry, I don't know. I am the shareholder or the partner, etc., etc. It is going to be a very costly affair. Whether provisions of Indian Evidence Act will be ignored in those circumstances because a document says she is the owner, oral statement says she is not the owner. That is a matter of debate and discussion, which we can deliberate at length of time. But the immediate consequence will be that notice will come. Part D is a residual clause, but this is the most vague clause, sweeping clause, anomalous clause, and troubling clause, I would say, where it clause says the property is benami where the pair of the consideration is not traceable or is fictitious. I can understand if it is fictitious, but not traceable means what? And not traceable to whom and by whom? Searched by whom? By Income Tax Department. No one wants to be identified by the Income Tax Department. No one wants to be traced out by the Income Tax Department. So if a pair of the consideration deliberately chooses to be non-traced by the Income Tax Department, that is especially its wing, investigation wing or BPU, then the present owner of the, property will be in great trouble. So we have recently argued one matter before Honorable Telangana High Court. Today was the hearing, and Honorable High Court has been pleased to grant stay on that, where we are challenging the constitutionality of 29D and also requesting the Honorable High Court to read it down and to replace this word not traceable to something else, non-identifiable or something like that. Otherwise, it is going to create disastrous results, causing a lot of unintended harassment to the people. I hope Dr. Gupta is going to also touch upon this issue today in terms of its interplay with Section 68. Then we have some exceptions. And what are those exceptions? Exceptions are, if the property is held in the name of Karta, okay, this is a very, acceptable exception, nothing great about it. Member, Karta, HUF, all. Second is very, very important. Person acting in fiduciary capacity. It could be partner, trustee, director, etc., etc. So sometimes properties are held by the firm in the name of partner or by a company in the name of director, holding, subsidiary relationship, etc., etc. There could be many issues which may arise, but let us conceptually understand today, and we can take up the issues later on. Then property held in the name of spouse or in the name of child. Very interesting issue. You know, this Benami law is giving different kind of shivering to different type of people. Now somebody is worried now because different type of shivering, different type of tensions raises different type of doubts and different type of questions. So somebody is worried lest his Benami property is not discovered, but someone else is worried lest his Benami rishta is not detected. So comes the question, and the questions sometimes are like this: Taneja sir, all right, it says that if property is acquired in the name of spouse, it will not be Benami, but the question is whose spouse? So I was also amused for a minute. Then I said, look, sir, actually, I have made this slide interesting. There it is clearly mentioned his or her spouse only, not someone else's spouse. So his or her spouse, if you buy property, it is an exception. Or in the name of child, any child, it is written any child. Now, any child means what? Not all that what you are thinking. Any child means child up to what age, major or minor. So I would say child is a child of any age. So spouse or child are in exempt category. So Mr. A buys property in the name of spouse or in the name of child. But hold on, there is a rider, big rider. It should be, the source should be out of known sources of the gentleman. Now this word known has also been noted by me for the first time, having been used in any legislation. It's not saying tax paid sources, declared sources, disclosed sources, it says known. Now we can deliberate upon the meaning and depth of the word known. Now, summarily, I would say known means something which can be identified, described. So for example, from this check, from this bank account and its immediate source is a salary, etc., etc., whatever can be said. I mean, they are saying you cannot take a plea that I don't know from where I have paid, but I have paid. No, they don't want to give you this much of liberty. You have enjoyed a lot of liberty already. Now the time to be disciplined. Brother, sister, linear, ascendant or descendant. It will be exceptional. It will fall in exception, but there is one very big writer. The gentleman has to be joint owner of such property. So Mr. A is buying property in the name of his brother, but he has to be joint owner in the registered deed. In the name of mother, father, he has to be in the joint ownership property. Otherwise, no benefit of exception will be given. This is also again very harsh provision because Many people innocently buy property in the name of their mother, mother-in-law, father, for emotional reasons, for many other pious reasons. But law says no, we want full transparency. Power of attorney cases, big trouble. We are handling many such cases where, such cases where innocently registry could not be done. Properties are held under power of attorney because of some restrictions under the law, that title is not being transferred by way of sale deed due to some legal hurdles. But still, the law says it will be covered. Only it will be given the benefit of exception only when two conditions are fulfilled. What are those conditions? Stamp duty has been paid on the same, number one. And number two, the contract of giving power of attorney is registered. Seems to be very simple, but friends, may I ask this question: in how many situations of power of attorney these two conditions are fulfilled? And all those cases where these two conditions are fulfilled, the conveyance deed would most probably be available. So power of attorney cases, unless some amendment is brought out. Today in Chandigarh also, I was having a discussion with an officer. He was also saying, Mr. Taneja, if we start applying this power of attorney cases clause, because exception is of limited nature, many cases will, get covered. So it will cause unnecessary hardship to many people, even in unintended cases. So, they are also in a fix what to do. Now, what do I mean by what unintended here? Whether intentions have been disclosed, whether any objects have been laid out. Amit Khemka sir quite often would ask me, Mr. Taneja, you have been discussing a lot on Benami, but whether any statement of object has been given. With due respect, I could not find any clear statement of object along with this law. I do not know why it has been done so or not done so. There should be clear statement of object, particularly such kind of prohibitory sweeping law, which is going to be very harsh. So therefore, the officers are properly guided that within what framework they have to invoke this law. But anyway, it is what it is. We have to face it as it is. Now, very important question which I want to raise here. Now, suppose anything is covered in A, B, C, and D, any particular transaction, either in A or in B or in C or in D, all are very quite sweeping. And it is not able to get the benefit of exception. Whether it will be Benami, even if it is done unintended so, without any malified intention, which Pawanji was asking me since morning, that Ashwini, tell me, there could be transaction without bad intention. So my answer is clearly is that yes, the law says so. There is no scope of bad intention, good intention, no intention. If it is Benami, it is Benami. One movie came na, no means no. For whatever intention the person is saying no, no means no. That is the end of the matter. So the law is so sweeping. Before I come to the authorities part, one other important question which comes to my mind is time limit. Past time limit as well as future time limits. Now, past time limit means whether the transactions done subsequent to 1/11/2016 would be covered, or transaction done prior to 1/11/2016 will also be covered. And not only that, suppose I have done transaction today, within how much period action can be taken against me if it is found to be Benami by any authority? Is there any time limit? So about past and future, what are the time limits? Again, time limits have been borrowed from probably Srimad Bhagavad Gita, wherein Shri Krishna said, समय अनंत है, ना इसका प्रारंभ है ना अंत है. तो इस बार the team who drafted this law also thought, इसको समय से क्या बांधना, ना इसका प्रारंभ है ना अंत है. So ना तो retrospective time limit दिया है, ना future time limit दिया है. Now on retrospectivity, there is a lot of litigation happening in the country. Presently, the matter is there in the Supreme Court. 2 high courts are in favor of us people and 1 high court is against the people. Chhattisgarh is on one side, Chandigarh, Calcutta High Court and Raisan High Court is on another side. Matter is pending before the Honorable Supreme Court. But whenever somebody asks me this question, I just request him to refer to clause A, which says property transferred to or held by benamidar. So meaning thereby, even if property was transferred earlier, but if it is held today, then any officer working under Benami law will try to invoke the provisions that today you are holding the property as Benami. Maybe you have done the transaction today, but your holding it makes its continuing offense. So I will invoke the provisions of this law. it's a worrisome situation, thing to be deliberated. And Honorable Shri, late Shri Arun Jaitley also said, we do not want to give immunity to the people who have done Benami transaction in last 28 years. So meaning thereby they want to cover in those transactions. Meaning thereby he says that those who are holding Benami assets, we cannot allow them to continue to hold Benami assets. So I mean, situation is really grim and worrisome, particularly for those who have done any such Benami transaction which is technically Benami, but without any intention to hold it Benami. Now, practically how the things go, after giving a little briefing on that, I think then I can pass on the forum to another learned speaker. Practically, it happens like that the initiating officer Benami Prohibition Unit has been created, which is part of the investigation wing of the Income Tax Department, which is flooded with huge information, which is being served on platter because of searches having taken place, people filing complaint, cross complaints from within the family, outside the family, where not. As I said, now interplay of agencies are taking place. You must have read few days back only, SEBI has also entered into one MOU with Income Tax Department. So both are in exchange of information. EOIs agreements have been entered with the foreign countries also, with ED between the ED and Income Tax Department also, so forth and so on. So there is a free flow of exchange of information. So information is coming on the platter. And many people are finding it very, very, charming to upload the photos on the Facebook, sharing the information on the Facebook. So the first cases which I got, one case was from Goa. So the car of somebody, fancy car of someone has attached because the family of that gentleman had uploaded one photo on the Facebook that we are proud owner of so-and-so car. So from there only BPO picked up the picture, saw the registration certificate of the car. Registration was in the name of some other company. Ostensible owners who were claiming themselves to be the owner of the car was somebody else on the Facebook, and that is how attachment was done. We are still fighting that case. So practically information is provided, and then the initiating officer, the enforcement officer is called as initiating officer, IO, is the rank of assistant or deputy commissioner of income tax. He has been empowered under the law under section 19 to make inquiry. Then if he is satisfied that this is property is Benami, then he can record reasons and issue notice under section 24(1). And simultaneously, by issuing the notice, he can also make attachment of the property under section 24(3). That is what makes this law as quite cumbersome, that immediately attachment is done. Then within 90 days, he has to complete the proceedings and refer the matter to the adjudicating authority. If he finds it to be Benami, then adjudicating authority takes around 1 year to dispose the property. Earlier, the adjudicating authority was common with PMLA and Benami law. Now, the competent authority working under SAFEMA is being given the jurisdiction to pass the properties, attachment of the properties, adjudicate upon the orders passed by the initiating officer. The pan-India jurisdiction is in Delhi today, but now the competent authorities are being created. And after the adjudicating authority passes the order, matter is then in the court of the appellate tribunal. So appellate tribunal would finally decide whether the property is Benami or not. So once the appellate tribunal passes the order, thereafter only confiscation can be done. So confiscation cannot be done prior to the passing of the order of the appellate tribunal. Till that time, only attachment orders are done provisionally. IO makes the provisional attachment order, which is continued by him and thereafter confirmed by the adjudicating authority if adjudicating authority concurs with the findings of the initiating officer. Then many authorities have been created to create interplay of the information which I have shared with you. Then I think there are many other issues which we can take up, many questions which Pawanji are raising. I think let us have the benefit of presence of the learned speakers which we have. So I think I will leave the stage or the forum as of now, and let us wait for the question answer session wherein a lot of things can be deliberated. But I'm really very happy to share my thoughts and my ideas on this new concept of Benami. And in times to come, I will request Pawanji, if it is also demand of the audience, to give a session where we can take up some ticklish issues of Benami and also interplays of these laws with each other. How this SBO concept, significant beneficial ownership concept under Companies Act, also interconnected with Benami, how money laundering is interconnected with Benami, how income tax and Benami also working all together, that additions are made under section 68 also, and the same thing Benami can also be treated as Benami, etc., so forth and so on. But for the time being, thank you very much, friends.
Thank you, Ashwini. Thank you very much for giving very lucid presentation and explaining the concept of Benami. No doubt there are so many issues. I will ask you during the question answer. Now time is to listen Dr. Rakesh Gupta. Gupta ji, I will request you. There are so many people are taking the entries. Entries mean that they are asking money and then they are adjusting money through other source. But the entry is in their books. Now this is rampant across the country and this was happening. So what is your view on this aspect of connecting to accommodation entry and Benami law or other issues which you think fit for discussion? Mr. Gupta.
Thank you, Pavanji. I'm speaking on this topic of Benami after a very long gap and recess. But then there is no worry in the sense that I am cradled and sandwiched. I mean, between two sets of stalwarts of the field. Initially, immediately after that amendment in 2016, I had occasion to deal with the issues under this PBPT Act, Prohibition of Benami Properties Transactions Act. And I do remember vividly that that made a very interesting reading and dealing with this law. Of course, the law is evolving. As Ashwini ji has told, the law is evolving. Not much jurisprudence is available so far. But there are issues in implementation. And because of the issues in implementation, the question comes whether this act is to be feared, frowned, or to be faced. As Ashwini ji has spoken about the impending litigations about the retrospectivity, that some high courts are in favor that it cannot be retrospective because it affects the substantive rights. Other high court, I mean, may not have favored that interpretation. The matter is now languishing. I mean, before the Supreme Court is seized with that matter. So the accommodation entries, as Pavanji has also, I mean, said the ball rolling. Accommodation entries, as the name suggests, are the accommodations. When the unaccounted income of a person or entity on which the tax is not paid is brought into the book without paying taxes in one form or the other, by taking recourse or help or the name of somebody else. And in that sense, I mean, there is an accommodation from that person or entity. I mean, these are called accommodation entries. Under the Income Tax Act, suitable remedial provisions have been enacted. We have got section 68, I mean, which says that if there is a credit appearing in the books of account, the source of which is not explained, then it will be deemed to be the income. So if there is an accommodation entry which is found in the books of account of a person, then the Income Tax Act says that it will be deemed to be your income, and on that there will be stepped up higher tax rate. And that tax rate is as high as 78% by taking into account surcharge and the cess. And of course, I mean, that is followed by the levy of penalty, though the penalty may not be substantial, but then the penalty nonetheless is there. Penalty is a penalty, penalty is stigmatic. And then is followed up by the prosecution. And the general belief, is evident from an attempt of the legislature to cover such kind of transactions. Now, whether that transactions, if at all, are covered in all situations is a thing now, I mean, which needs to be debated. But definitely the attempt of the legislature was to reach to these transactions under the PBPT Act also, so that the deterrence can be created. In fact, I and my senior partner, Dr. Raj Agrawal, happened to write one article, and which I mean is coming very shortly. And I mean, both of us are in the midst of writing the book on Benami also. And therefore, I thought that, and it has created a rekindled my interest, I mean, this topic. So if we see the accommodation entries, now broadly we can categorize these entries where there is a bogus share capital or the bogus cash credits in the form of say loan, for example, are found and declared by a company. For example, let us be very specific, as its unaccounted income and which are credited in the books in the name of somebody else. This is one situation. And the variation of this is that where the bogus share capital or cash credits are declared by some individual or director of a company to be his own income, unaccounted income, and introduced in the books of account, say the books of accounts of the company by way of issue of share capital or unsecured loan in the name of some other entity, and that amount is received through the banking channel, then what would happen? So let me take the first instance where there is a bogus cash credit declared by the company as its unaccounted income. And this I would try to explain with the help of an example, and then we will see now whether it is covered under 29A, 29B, 29C or 29D. And if at all, in certain situations, whether it calls for the kind of fear, I mean, which is often debated, which is often ignited, and that is to be seen. Now, suppose there is a company, ABC Limited is a company, now which has taken an accommodation entry as unsecured loan from XYZ Limited. And this entry was taken by procuring the amount through the banking channel. Now, cash has been paid, the check has been taken. ABC has taken a check from XYZ, and during investigation, now ABC admits and accepts that it was its unaccounted income and which has been paid in cash to XYZ Limited for procuring the accommodation entry of the unsecured loan. And this fact is also accepted by, I mean, that name lending company, that is XYZ. Now, of course, the department would say on the parameters of these sections, which defines Benami transaction, that XYZ Limited is benamidar, in whose name that unsecured loan stands. ABC is the beneficial owner, and therefore this transaction, the department would claim, is covered under the PBPT Act. In fact, for the application of a transaction or application of the PBPT Act, now there has to be the three ingredient which has to be there. There has to be benamidar, and there has to be beneficial owner, and there has to be a Benami property, which is the subject matter of Benami transaction. Now, in this example which I gave, XYZ Limited is benamidar in whose name the unsecured loan, I mean, is held. ABC Limited is beneficial owner who has paid the consideration and for whose benefit the Benami property is held by the benamidar. And therefore, the department, as I said a little while ago, would urge and say that this is a Benami property and this is a Benami transaction. But then that is not the end of the road. And when the courts will be seized with this kind of a situation, and then the courts may find that this kind of transactions may not be covered because the cash which was earned by ABC and which was given and it has been received back in the form of a check from XYZ. Now, that money which has gone has come back to it. Now, therefore, in such a situation, now where is the Benami property? Because it is an admitted fact by both the parties that the loan given by XYZ by way of check transaction has been received back. I mean, though these interpretations may be quite revolutionary, but then if the language of the law as it stands today, now, I mean, can admit, I mean, more than one interpretation, then of course, I mean, another interpretation, I mean, that this interpretation is bound to be accepted. Otherwise, I mean, then this open and shut case that this is a Benami transaction. So in this case, since the Benami property is not existing in this case, and this is admitted by both the parties, that loan given by XYZ Limited by way of check transaction has been received back by it in cash, and therefore there is no realizable asset comes into existence. So when a person which has given loan has received it back in cash, no recoverable asset now can be said to be created. And in this case, there is no realizable or actual asset. Therefore, the very spirit of PBPT Act in this case, that doesn't find place. And therefore, in such a situation, but of course, since ABC has admitted this is unaccounted income, there may be consequences under the Income Tax Act. But then whether this transaction, if at all, can be covered within the ambit of Section 2(9) under the Benami PBPT Act, now that is a question now which is not free from doubt and debate. Similarly, in case of the bogus share capital declared by company as its unaccounted income. Now, if in the above example, instead of the loan, if suppose accommodation entry is taken in the form of XYZ Limited subscribing into the share capital of ABC, and of course, check has been received, the unaccounted income which has been so admitted by ABC now is paid. Now here some variation which comes is that here the shares which are held by XYZ Limited now are something which are independently transferable asset, and therefore whether in such a situation can it be said that equity shares issued by ABC is the Benami property in the hands of XYZ Limited. Now in such a situation also, since XYZ Limited has admitted that in lieu of the share capital which has been issued in its name, ABC Limited has already paid equivalent amount in cash, then no claim as to the asset in the form of share capital can be raised by XYZ Limited. And even if the shares are transferred to somebody else by XYZ Limited, such other person cannot acquire any valid title to the shares, and ABC Limited also may decline to transfer such shares. Therefore, such a transaction, since has been treated by ABC Limited as its unaccounted income, then there may be consequences, as I said a little while ago, under the Income Tax Act. But whether such transactions can be roped in under Section 2(9) now is something on which can be debated. But then if instead of ABC Limited admitting it as its income, now if the director of ABC says that this is his income which he has given to XYZ Limited in the form of cash, and that XYZ has subscribed share capital in ABC, now in that situation there is a difference, because then this transaction, because here A, who has provided the consideration, in this case A has provided the consideration, may not be the beneficial owner of the shares, because the beneficial owner is the company. But in that situation, it will be difficult for A to avoid the applicability of, because after all, consideration has been paid by him, shares have been held in the name of XYZ, or the beneficial interest is there, and he directly or indirectly, because he is the director of ABC Limited, holds the interest in those shares, and therefore it may be difficult for him to avoid the applicability of the prohibition of the Benami Property Act. So not all accommodation entries, despite the omnibus intention of the legislature to cover within the definition or within the meaning of Benami transactions, may not be covered. There may well be the situation where the legislature finds that there is a lapse in the drafting of legislation, and therefore the necessary repair work should be done. That is a different matter. But something can be made out even in case of accommodation entries, that it is outside the scope of the existing provisions of law. So Pawanji, this is what, because I have to speak for about 10 minutes, and Therefore, I'll give quietus to, because Amitji and Dash sirs,
Thank,
considerations we all are waiting.
okay.
So I give my thanks to you for giving me this opportunity, and you will find me more often now. And with this, I give quietus to my this deliberations. Thank you.
Thank you, Rakesh ji. Thank you very much for explaining this. Now I'll request Amit Khemka ji. Amit ji, this prosecution is in the part now, integral part of Benami law. So how to protect, what are the prosecution's nuances? Please explain to this.
Thank you, Pavanji. It is always a pleasure to listen to Ashwini Taneja ji and Rakesh Gupta ji. Rakesh ji, whenever he speaks, he comes up with something which we may not have even thought of. Now, coming to the prosecutions under the Benami law. Today, as the statute exists, there are two different provisions for prosecuting the offenses or the offense of entering into Benami transaction. One provision is for prior to the period 1/11/2016, that is the date when the new amended law came into force. And the other provision is post the new amendment. Of course, the issue of retrospectivity remains, as Ashwini had very lucidly explained. But fortunately, so far as the provision of the new provision of prosecution is concerned, or it has been clarified that that provision will apply only post 1/11/2016, that is the date after the new law or after the amendments have come into the force. Interestingly, the definition of Benami transactions prior in the old act and in the amended act, it has changed drastically. In the old act, it was merely a one-liner. The definition said Benami transaction means any transaction in which property is transferred to one person for a consideration paid or provided by another person. This was the only definition. And interestingly, that this definition is no more on the statute book. But the provision relating to the prosecution on the basis of this definition continues on the statute book. That provision said that whoever enters into Benami transaction shall be punishable with imprisonment for a term which may extend to 3 years, or with fine, or with both. That was the pre-1/11/2016 situation. So if a offense, if a person had entered into the Benami transaction prior to 1/11/2016, he is liable for prosecution or imprisonment up to a term of 3 years. The question arises that which definition of Benami transaction will apply in case of the prosecutions prior to, for the offenses or for the Benami transactions entered into prior to 1/11/2016. The definition which existed earlier, or the definition which now exists by way of amendment. It is trite law that a prosecution or a penal provision cannot have retrospective effect. and if the new definition will be utilized for the purpose of prosecuting the offenses under the old act, the effect would be that a new offense, in a way, with a retrospective effect, would come in. Section 3.3 of the new act now says that whoever enters into a Benami transaction on or after the date of commencement of the amended act of 2016 shall, notwithstanding anything contained in subsection 2, that is the section which I read for the earlier period, be punishable in accordance with provisions of chapter 7. Now I'll take you to the chapter 7. We are receiving notices from the IOs in respect of the transactions which were entered into prior to 2016. And interestingly, even the officers of the department are not very sure which definition should they use and which provision should they use. While the notice is under section 3.2, which is the old provision for prosecution, the definitions which are being utilized are both the one which is no more on the statute book and also the one which has come in on the statute book, that is section 2.9 of the act, post the amendment of 2016. So even the department is not very sure of which definition should be utilized for it. And therefore, they try in the show cause notices to insert both the definitions and try to bring the offense under both the definitions. The other question arises is that when I'll deal with the post 1/11/2016 definition and what is punishable after that, there is an element of mens rea. But in the pre 1/11/2016 definition, there is no element of mens rea whatsoever. The very factum of entering into Benami transaction was punishable or is punishable. So the question will arise again, as the Supreme Court says, that where the mens rea is not prescribed or provided for, it will have to be seen, the intention of the act will have to be seen, the scope of aims and objects will have to be seen. But as unfortunately this act does not have any such aims and objects, it is difficult to understand that whether any and every Benami transaction is liable for prosecution. Fortunately, so far as the transactions before 1/11/2016 are concerned, as Code of Criminal Procedure is applicable to these prosecutions, and there is a provision of limitation prescribed under 468 of CRPC, according to which the offenses where the punishment prescribed is up to 3 years. There is a limitation of 3 years prescribed. But the rider is that the limitation will start running from the date of knowledge. So the date of knowledge, at the moment, what the department is claiming, the date of knowledge is the date when the matter is referred to the BPU unit, that is the Benami Prohibition unit of the Income Tax Department. But interestingly, these references are made by almost the same department of Income Tax Department. So the other question will be that when the transaction was already in the knowledge of Income Tax Department, can it be said, will the limitation be still start from the date when the matter was referred to BPU unit? And why not from the date when it came in the knowledge of the income tax department only? Or the date when it came into the knowledge of income tax department in some other earlier proceedings, or it was declared to income tax department. So all these questions, as Dr. Gupta said, and as Ashwini sir said, that the jurisprudence is evolving. The prosecutions have just started only few months back. They are launching prosecutions and sending notices now. So this law has to evolve. Now coming to the prosecutions after, the offenses which have been committed post 1/11/2016. Fortunately now it is not a rampant provision, just like the provision which existed on the statute book, or which still exists, section 3(2) of the act, where every Benami transaction, irrespective of any mens rea, irrespective of any malafide, has been made punishable or penal. Fortunately, for the offenses which are committed post 1/11/2016, now there are only 3 conditions in which entering into a Benami transaction has been made punishable. Number 1, where the purpose of the Benami transaction has been entered into in order to defeat the provisions of law. B, if it is made in order to avoid payment of statutory dues. And C, if it has been made to avoid payment to creditors. And who all are liable to be for prosecution, that also has been specified now. Earlier, it was not specified. It just said, whoever enters into a Benami transaction shall be punishable with imprisonment. Today, it is the beneficial owner, the benamidar, or anyone who abets or induces such a Benami transaction shall also be punishable with the same punishment. But at the same time, while the mens rea has been included in these, while it has been specified that it is for in order to commit a particular situation, the offense today has minimum punishment prescribed. The maximum punishment is 7 years, and minimum punishment is it will not be less than 1 year. So that is for entering into the Benami transaction. Then there are offenses where if any false information is provided, that is also punishable. If there is for the notice is not complied with, or the information is not furnished in response to the notice of the officers, then also there is a punishment prescribed. I think those are prescribed almost everywhere, almost in all the economic laws, they are there. So, but that was, I think we have very short time and we have to go back to the question time. So I'll just, these were some important things which we can go on. There are many contentious issues, but right now we will try to deal with them in the question session, and over to you, Pavanji. Thank you very much for giving me this opportunity.
Thank you, Amit Khemkaji. Now turn to Dr. R.N. Das. Sir, I have received various questions, and I'm asking because you have a experience and you have well-established name in this particular economic offense. Sir, this 2016 Amendment Act was enacted to foster the effect of government to curb the parallel economy and eradicate the black money. How far have been these objectives we have achieved?
First, let me clarify. I have no experience in doing these Benami transactions. So,
Benami transactions may not be done by you.
inadvertently, you implied that. Second thing, in fact, it was very nice of you to give this name, new Benami law, to a law that was done in 1988. 1988 law, you give it the name new Benami law. That is because you understood it correctly. Because it was a paper tiger when it started. It was not effective. It became effective only when it started in, it was done in 2016. I must tell you, this law has gone through ups and downs. How ups and downs? Initially, in 1972, Justice P.B. Gajendra Gadkar, in 57th report of the Law Commission, suggested a very lucid, small Benami law. And that was when right to property was one of the fundamental rights also. I am specifically saying those who are interested in fighting it out in constitutional courts, consequently, they should study really from that date. Government did nothing out of it, sat over the report for 15 years. And suddenly, because of a certain political reasons, they issued an ordinance for recovering the Benami properties in 1988 and wrote to the Law Commission, then headed by Justice D.A. Desai in 1988, in July, stating that you give us a quick report because it has to, the ordinance will lapse in 6 months. So in less than a month, the Law Commission hurriedly gave a report whereby all Benami transactions were made an offense. And what they did, that prohibition of Benami was made legal. And third thing, all Benami transactions were tainted with the illegality, illegitimacy, and criminalized. So it is on the basis of a venerable institution like a Law Commission who didn't have much time to do it. And if you go through the reasoning, Dr. Rakesh Gupta, you will be appalled. The reasonings that they have given that the wealth, so much of wealth around is so bad. Like you will think that it is not Law Commission, but somebody is a politician speaking from a restaurant. But in any case, it was done so hurriedly. The law was passed. It was never implemented from 1988 till a new government came. And who came in such a hurry? They bypassed such a beautiful report of a parliamentary committee headed by, about which Ashwini Tanejaji really dwelt on that. And that is also another document that needs to be studied and looked into to see the loopholes in this law. So they thought by bringing this law, they will eradicate entire black money. But we had nothing to show that the entire black money in the country was in Benami names. And they ignored the fact the Benami has been a way of life. It was legal in the historically for such a long time, and it has been made illegal so quickly. So, and how to implement it properly in a law that has only 72 sections, and where there are so many loopholes about which all of you have pointed out. As Kemkaji told, the mens rea in respect of a punishment is there. So, but there are certain honest transactions where there is no mens rea. How about that? You cannot punish there, but you can confiscate there. So these aspects have not been really looked into properly. It has again been done in a hurried manner, quickly, and its implementation is also, you see, within 40 days, what can the poor fellow do? He cannot even have time to give adequate opportunity for something. So all these things taken into consideration, it is, I find, the 2016 amendments are well intentioned, but they were harsh, draconian, and will not be able to give you the desired results. It will create lots of problems around. And if it is implemented with an iron hand, probably most of the country will be found to be Benami held, even in rural areas. The agricultural property. We had a joint family system in which properties were held by many people in the family, uncle, aunt, this thing. But those exemptions have not been found way to the act. So all said and done, it is a well-intentioned act, but only when attended with a certain criminality, the Benami transactions should be prohibited and acted upon. And in this fashion, it is not going to do much. It will create lots of litigation only.
Okay. Thank you very much, sir. You have explained the concept, the background, and your experience. That is very useful for everybody. Dr. Gupta, what will be the fate under Benami law of the bogus share capital loan added under Section 68 of Income Tax Act?
No, I mean, you are asking this question under the Benami Act. I have already answered this, that though the legislature has sought to cover it within the definition of Benami transaction, but then where now it has been admitted that this is unaccounted income by say in that example ABC and XYZ both, then the situation may be different and may not be covered within the net of Benami transaction. That is what I just wanted to highlight.
Okay. Now I have to just structure. So Ashwini ji, Amit ji, and Gupta ji and Das sir, I have received so many questions also, and previously they have sent. So there are two types of questions. One is explainable, and second is that we can give yes and no. So what I'll do, I'll ask you questions which are bigger one, but after some time we will go for rapid round where you have to just tell yes and no, so we can cover maximum question. Ashwini ji, is Benami transaction applicable to both movable or immovable property?
Sir, before you start wrapping round, one thing I wanted to say, there is one very, very important question which is bothering many people in the country, and this has been asked today also in question answer session.
Yeah.
Probably Atul Puri ji has asked or Sarda Hariharan ji asked. Yes, this is a very important question. It's bothering everybody in fact. And that question is that if I have done Benami transaction, so whether law gives me any scope to take to correct it, like settle it, compound it, anything, because every law, particularly in countries like America, every offense is compoundable. There is some stage whereby one can say, okay, that is over now, let us make a fresh beginning on the clean slate. So what is the situation under Benami law? I mean, unfortunately, this crime is not so heinous, I mean, in my personal opinion, that you should not have given any way out to get out of it, the clutches. There is no concept under which I can correct the mistake. Rather, the law says otherwise, that no property shall be transferred by the benamidar on the instruction of beneficial owner, directly or indirectly. So if it is done so, that such transaction shall be void under section 6(1) of PBPT Act. So meaning thereby, I could not find any scope whereby I can correct, I can put the clock back. I can say, all right, I have done this mistake. I am ready to do the way you want. I am ready to discipline myself. And you know what is the probable rationale behind it? That one window was provided by way of section 190, and they say you should have adopted that window. Now that window, I mean, it came and it went. Nobody noticed what was that, what was scope. I mean, with due respect, that window that cannot be taken the sole excuse not to give any.
People should have foreseen that. I mean, instead of income declaration, so some other act would come.
Missile is coming.
Yes, and that is.
All right, you pay stamp duty, you pay tax. I mean, these kind of riders could have been put. But how can you not give a person a opportunity to make a fresh life? I mean, live proper with proper discipline. Everything should give. So that is a fundamental question. And that coming back to the another question which you are saying, if you see the definition of the word property, I think it is widely and wildly given. Any damn thing on earth which you can see, touch, will fall in the definition of property. Any damn thing. Even intangible properties are also covered.
Is it can be loan or can be also be property?
That is, loan is an asset in the balance sheet, and if it is an asset is clearly coming within the definition of property.
And what about goodwill, which you can't touch?
I mean, say even intangibles are covered. So those you can touch or could be covered. Even intangibles are covered. So and someone can read. DASA is probably going to read the definition of the word property. So,
you see, I think this definition, if anybody will read, it is appalling, Rakeshji. It is 226.
Yes.
Property means assets of any kind, whether movable or immovable, tangible or intangible, corporeal or incorporeal, and includes any right or interest or legal documents or instruments evidencing title to or interest in the property, and where the property is capable of a conversion into some other form than the property in the converted form, and also includes the proceeds from that property.
So that's, sir, it means if I have an idea will also be a property, whether it is written or not. If I am able to sell this idea.
No, the idea is being your own creative idea. It can't be Benami. So you will not be affected by that. But the idea, the moment you take a patent on it, that becomes a property.
Okay.
And if you have the idea, but you take the patent in the name of not your wife but your girlfriend, then that will become a Benami transaction.
Okay. Amit Khemka ji, is it correct to say that element of mens rea has been totally ignored in Benami law? How have the court viewed over the year, as per your experience, whether the bona fide intention, motive of the person can be escape route for such transaction can be excluded from the proceeding under the new under the Benami law?
Under the new law, the amended law, as I explained, section 53 does include the mens rea into it. So that is, I said that it is actually a very great sigh of relief that a person is not prosecuted, at least without mens rea. So prior to 1/11/2016, whatever Benami transactions have been entered into, those transactions, there is no mens rea provided for. So many times I tell Ashwini ji that this Benami law should have been restricted to the situations covered by section 53 of Benami law only, where the Benami Act was intended to either break the law or to avoid the law or to defeat the law or to avoid the payment of statutory dues. Then only it should have been made penal, or where the property was liable to be attached. It should not be that every act of Benami transaction, which for centuries in our country has been happening, Benami transaction was a legal transaction prior to 88. In fact, a Benami beneficial owner could recover his property from the benamidar prior to 1988. So this whole change in the law, and it's so drastic law, it cannot be in this manner and overnight.
Okay, okay. Ashwini ji, the
Sir.
step brother sister is covered in this exception.
No, exception is not even covering fully brother and sister, what to say of step brother, sister. But they are saying in case of brother, sister, now we'll have to see the definition and the Hindu Succession Act and other applicable laws, allied laws, whatever has been given. And whatever definitions are there, those will be applicable here, number one. Number two, there also it will be joint ownership only. Only on joint ownership basis. This is to be kept in mind because this small slippage can cost a lot. You cannot buy in the name of my mother, my sister, my father. I can buy only in joint name. Somebody says, can I not give to my mother? Who stops you from gifting? यार बेनामी लॉ तो लाए इसलिए कि जो आप करना चाहते हो, जैसा करना चाहते हो वैसे ही करो. ये नहीं कि आप करना कुछ चाहते हो, दिखाओ कुछ रहे हो. नो, अगर आप मदर को गिफ्ट करना चाहते हो तो गिफ्ट कीजिए, फिर आप भूल जाइए कि आप ओनर हो. बैलेंस शीट में आप अपने आप को ओनर दिखा रहे हो, उसके रेंट ले रहे हो. वैसे डीड आपने मदर के नाम से ली है. ये क्या बात हुई? So do whatever you are doing.
आप रहते हो या
Sorry?
या मदर के नाम में घर लेके उसमें रहे आप रहे हो. पेपर वर्क पूरा कर दिया, गिफ्ट भी
नहीं रहने में भी I can
actually गिफ्ट.
my mother can permit me, but I should not simultaneously claim myself owner. That's what I am saying. रहने को मदर मेरे को रहने के लिए दे सकती है, उसमें क्या प्रॉब्लम है? I can be permitted to use.
अश्विनी जी इसका मतलब है दुर्योधन को तो अगर दुर्योधन आज होता बेनामी लो होता तो द्रौपदी पे केस कर देता कि आपने दिखाया क्या और बनाया क्या. Okay, now there is another point. The purpose of section 54 invests the sale proceeding in the name of mother-in-law. What will be the status?
मदर-इन-लॉ.
हाँ.
मदर-इन-लॉ तो कहीं एक्सेप्शन में है ही नहीं, जॉइंट ओनरशिप के एक्सेप्शन में भी नहीं है.
ओके.
तो जॉइंट ओनरशिप के एक्सेप्शन में लिमिटेड है. आप उसमें वाइफ्स ब्रदर कवर नहीं है.
ओके. So now I'm coming to the rapid round. So please excuse me because we can cover more. Gupta ji, whether the IU has power to making arrest of the offender under the Benami law?
No. That power is not there under the Income Tax Act also.
Okay. Ashwini ji, you were giving a presentation. In the presentation, you have shown A, B, C, D. So in the B, you have seen fictitious name.
Yes.
And in the D also, you mentioned fictitious. So what is the difference between fictitious name and fictitious?
No, they are the pair of the consideration. In B, the asset is held in the name of fictitious person. In D, the pair of the consideration is fictitious.
Okay.
Both the situations are different.
In B is benamidar, in D is the beneficial owner.
Okay. The Khemka ji, whether the writ jurisdiction of High Court can be invoked to challenge any show cause notice issued by this new law?
Of course, Ashwini ji has today only got a stay from Telangana High Court on that. He has challenged the show cause notices issued under the Benami law today before and challenged the constitutionality of the law. And he has not only got a notice issued, but he has also got a stay today of the proceedings.
I will put something very important. With your permission, I will put something very important. We have challenged the constitutionality more specifically of 29D and requested the Honorable Bench to read down the rigors of 29D. And something fell from Dr. Gupta right now that in D, he is beneficial owner. No, I am on this point only. In D, it envisages there is no beneficial owner. If they are able to envisage that so-and-so person is beneficial owner, clause D cannot be applied. And that is what they have done in my case. They said, okay, Mr. X is beneficial owner and we are applying 290. I said, you cannot apply 290. If you identify 290, he is the beneficial owner. He is the pair of the constitution. What the hell you are applying 290? And Honorable Justice Ramchandar just picked up this point very nicely. He said to the standing council, yes, how can you apply then? He is aware, you are aware who is the pair of the consideration.
Okay. Gupta ji, the IU has a power, you are saying not to arrest, but they have a power carrying out survey and search and seizure like income tax in Benami.
No, these are the very specific powers which have to be conferred by the statute. And the absence of such provision under the Benami Act, there is no power of survey, search or seizure.
Okay.
What they are doing is that,
Amit ji is saying something very important.
But what they are doing is that they do everything, all the
Income tax.
everything under the Income Tax Act and then utilize it under the Benami law.
So
Okay.
that is what I was saying. My colleague is sitting with me, Parikshit. Parikshit just informed me in one case what happened. Now the officer has issued prosecution notice now. That very BP officer was in the search team and he recorded the statement and he is counting the limitation of prosecution from the date when reference received. Now Prashikji is telling me that he was part of the search team. So therefore, limitation should be counted from that time he himself recorded the statement.
I beg to differ. I beg to differ.
Okay.
But I will just make it possible.
He is a different authority then.
I will argue, put forth the limitation.
Of course, I am saying both are income tax departments, sir.
No.
There is
No. He was officer of the BPU at that time also, and he was included in the search team. That is what I am saying.
that is fine.
He was an authorized officer.
Yes, he was an authorized officer, but
Yes.
executed in BPU only, holding the position in BPU only.
Maybe.
Okay, Amit ji, whether parallel action can be taken under various economic offense law of the same transaction or economic offense of law is debarred if the provision of PVT Act is applicable.
Sir, it is something. What the question you are asking is that if a person has trespassed and after trespassing he has committed a theft or a dacoity, so which offense will he be convicted for or prosecuted for? He will be convicted for both. So we have cases where people are being convicted under 4 laws for the same act.
Okay. Ashwini ji, what action can be taken by authorities in non-disclosure of SBO in Companies Act? Significant beneficial owner under the Benami property.
Non-disclosure, BPU cannot take any action, but for disclosure to comply with the disclosure norms and it fits into the definition of Benami simultaneously, action will be taken. But somebody is saying, look, X is a registered owner, but its real owner is Mr. Y under SBO regime. Then definitely wait for the Benami notice.
Okay,
Because
I'm just
bringing out transparency will not absolve that X and Y from the clutches of Benami law.
okay. This is connected question. If I give disclosure of SBO under Companies Act, will suffice to Benami Property Transaction Act?
It will not suffice because if apparently admittedly it is Benami, rather it will be more easy for Benami unit officers to administer the law. And they will say, admittedly, you are saying he is registered owner, he is beneficial owner. Now tell me how you get out of the Benami law provisions. If the other conditions are satisfied, either of A or B or C or D.
Das sir, what are the consequences of doing a Benami transaction and whether these would remain same and inevitable irrespective of being malified intention or otherwise?
Sir, you are asking a question which has been answered by Khemkaji in a roundabout manner.
Okay.
Let me still, I'll clarify it in a straightforward manner. It is like this. The main serious thing that you are dealing with, the guilty mind. Guilty mind in respect to a crime is of 2 kinds. That crime of a basic intent, crime of a specific intent. Because the Benami transaction has been made illegal by law, merely entering into Benami transaction becomes also a crime of a basic intent. It is of a minor intent, this thing. For that, your property will be attached and will be confiscated.
Okay.
But if read with 3.3, 2.9 and section 53, you require something more. That is of a specific intent. If in addition to entering into Benami, you are also indulging in something else, like defeating some law, not paying certain taxes, committing some other civil offense, then in addition to this attachment and confiscation, you will be visited with the prosecution and jail.
Okay. Nice. I think you have explained very well, very nicely. Ashwini ji, time is over. So there are some few questions connected to you. So you just give me yes and no so we can cover the maximum part. Okay. Whether transaction in the past and properties held presently can also be attached under new Benami law?
That is what I said. Because of the word held, this is creating trouble. and Supreme Court is seized with the matter. But I will say serious situation is very serious because of the user of the word held.
Okay. Whether there is any time limit under this law for making attachment of the property purchased today?
That is what I said. Time is eternal. It has no beginning, no end. No time limit has been prescribed on the
Very interesting question as asked by a panel, the participant. Now we have seen if a professional is holding shares in the name of the client, company will be the Benami transaction as the holder of shares is an individual and the payment is made by the client. So normally, pardon?
I saw that question.
Yeah.
The issue is whether it can be put in the fiduciary capacity definition. If yes, only then. Otherwise, there is no saving. And fiduciary capacity benefit is still retained. There is one judgment in the name of Marcel versus Martin. There they say even the defined fiduciary capacity, I mean, one can go beyond the defined fiduciary capacity also, provided they're able to show it is in fiduciary capacity. Now, in the name of a professional, I do not know how will they satisfy this, because fiduciary capacity is like a trustee, like a partner, like a director, etc., etc. I think this is an issue to be deliberated. I mean,
Okay, Amit ji, now so many professionals are making companies, so and their registered office they are keeping at their own office or the professional's office. No doubt the shareholding is held by the main person, but the office is registered office is your office. Will it be treated as Benami?
I don't think so.
Okay.
No.
Okay. Ashwini ji, whether property.
One thing is to be taken care of. Who are the shareholders? If again the shareholder is not the one who is real shareholder holding on behalf of someone, then there may be a problem in such cases also.
Yes.
Okay. What about property acquired in the name of wife or children?
That is in the category spouse and child is exempt, provided it is paid from known sources.
Okay. And girlfriend?
Your own.
And girlfriend?
Wife also, your own wife and your children.
Yeah, that's right. So Shriji, living relationship persons, what?
It should be within the definition of spouse. If you can bring somehow fit in the definition of spouse, whosoever he or she is, all right. Otherwise, not.
But this definition is very fluid. There's no that live-in relationship is.
I think legally married only.
Okay. Is there any protection of the purchase who had no knowledge of Benami transaction? Any protection available to bona fide purchaser under the new law?
No, there is section 27(2), which says that in case a person has done a transaction from another person which was held as Benami, but the person buying the property is not aware of that it is Benami and paid adequate consideration for this, I mean, then protection will be available, and then this property cannot be attached.
No, his question was somebody has done it without knowing the rigors of Benami law. He didn't know about Benami law.
Bona fide purchaser, he is saying.
No. Bona fide purchaser
is there any protection to the purchaser who had no knowledge of Benami transaction?
Okay.
Any protection available to a bona fide purchaser under the new law?
Okay.
We have two judgments in our favor. Fortunately, we argued these are the first judgments of the country. One is Virgo Township, other is Kavita Infrastructure from the tribunal only, appellate tribunal of Benami law, where they have said that no such then 27(2) is available and that cannot be attached. It was attached, it has been released. Order is available on the site of the tribunal. Beautifully written judgment by Honorable Justice Manmohan Singh. Sitting as chair of the appellate tribunal.
Okay. So now, is there any scope of U-turn if Benami transaction is done inadvertently? Ashwini ji?
You have already answered that. No.
Okay. Please explain to concept of fiduciary capacity as envisaged in exception under section 29A.
I think Pavanji, it will require another half an hour to explain fiduciary capacity. And
Okay, now what is the meaning or scope of expression known source? Ashwini, very briefly.
Something which can be described, like I can say this is the check given from this bank account from this source. Something which can be identified, described.
It has been imported from Prevention of Corruption Act, section 13. Though it has not been identified here, known sources legally occurs there. So interpretation of known sources for the purpose of a prevention of a corruption act with a certain modification will probably apply.
But
Okay.
sir, unfortunately, this term has not been defined even in PC Act. What is known source?
No, no, it has not been. But there have been a large number of case laws.
All right, sir.
Okay. Amitji, last question. Please throw some light on the concept of burden of proof under Benami and whether it's different or same as in other laws dealing with economic offense.
I will start and then Ashwini can conclude. You know, in many other law, there is a reverse burden of proof, partially, fully, and of mens rea and so on. But fortunately, in Benami law, the whole onus is on the department or on the prosecutor. There is no reverse burden as such prescribed under the Benami law, but Ashwini ji has his own way of interpreting the laws, so he'll just conclude.
In fact, this is a very wonderful thing to analyze burden of proof under any legislation. And as Amit ji said that there is a reverse burden of proof in PMLA, but fortunately here there is no such proof and there is no provision. There is no clause about reverse burden of proof and there is no provision. So since there is no provision, the common law jurisprudence, the principles, sound principles of jurisprudence will be applicable. Honorable Supreme Court has way back said that the burden to prove is upon the person who alleges. So here the allegation being made by anybody that this property is Benami or so-and-so person are Benamidar or beneficial owner, the burden will be upon whom? Upon them only. And that is what Honorable Supreme Court has said, that under Benami law also it will be applicable. Now after coming into PBPT law, IOs were of the view that no, after coming into this law now, these judgment will not hold good. Fortunately, we argued one matter again, fortunately, before Honorable Justice Manmohan Singh in the appellate tribunal, and then they have given a very, very detailed judgment, well-reasoned judgment in the name of Pamela Bhardwaj and Ramdeep Singh Kochar versus IO Chandigarh. And their honorable bench has held that there is a good connect between those judgments and PBPT law. PBPT law does not lay down any different provision. So therefore, the sound principles of jurisprudence that the burden of proof is upon the person who is alleging. That is here the IO is alleging. So primary burden remains upon the IO to prove that so-and-so property is Benami, so-and-so transaction is Benami, or so-and-so persons are Benamidar or beneficial owner, and how.
Okay. Thank you, Ashwini ji. Thank you very much for Das sir, Ashwini ji, and Khemka ji, and Rakesh Gupta ji. Now, before closing, I'm giving 1 minute to all speakers to just summarize this Benami law in 1 minute. Das sir, I will start with you.
This Benami law in 1 minute, I can say, is requires lots of modification, improvement, at as quickly as that is made by the lawmakers, that will help the people.
Okay, Amit ji.
Me and Ashwini ji, we were addressing the BPU unit in charges from all over the country in 2017, I suppose, or 2017. Yeah, 18 February. So one sentence which we told them that day was that that lot of discretion has been bestowed upon you. If you exercise the discretion reasonably, then this law may not be set aside. But if you do not exercise that discretion reasonably, then there are many things because of which the constitutionality of many provisions of this law will be under challenge and may be struck down by the courts.
Okay. Ashwini, last word from you.
Yes. Actually, I would say, sir, in this manner, with the help of this law, I quite often say, and I believe so also, that we can also get the guidance for life. It teaches us how to live life. Something which you do not think, don't portray. Something which is not yours, don't tell others that it is yours. The way you are inside should be outside that way. So get rid of Benami life and live real life. Thank you very much.
Thank you very much, Ashwini ji. Thank you very much. So thank you, Das sir, Amit ji, and Ashwini ji, and I thank you all the participants, those who have come in big numbers here, because this is a very technical topic. And today we got more than 270 people who have participated during that period. So thank you. And I, on behalf of corporate professional, I thanks especially to the all participants, those who have participated in this program. And now in the continuation to our knowledge sharing endeavor, next Friday, we are having program on POSH. This is prevention of sexual harassment. That is a very important topic and a very essential topic for all companies. It is not, this is not exempted that who and what types of organization. Every organization has to do this. They have to follow certain things, and the law is very serious on this aspect. This is a moral law also, and this is social law also, and as well as this is a law which require the protection of the other half of the population. So for this, I thank everybody, and we will meet you again on the next Friday, same time at 4 o'clock on POSH, the prevention of sexual harassment. Thank you very much. Thank you, everyone.
Thank you.